Hello, everyone. Welcome back to our channel, U.S. Immigration News. U.S. implements stricter photograph rules for immigration documents to strengthen vetting processes. U.S. immigration authorities have tightened rules on the use of photographs for immigration documents, limiting how old a photo can be and ending the acceptance of self-submitted images. The new policy, issued by the U.S. Citizenship and Immigration Services, takes effect immediately and is aimed at reducing identity fraud and strengthening national security. Under the updated guidance, USCIS will only use photographs that were taken within 3 years of the date a person files an immigration form. Photos older than 3 years will no longer be accepted for creating secure immigration documents. USCIS also said it will stop accepting photos submitted directly by applicants. Instead, only photographs taken by USCIS or other authorized entities will be used. USCIS said the change is designed to ensure that every photo used in immigration documents is recent and reliable. The agency said this is necessary to prevent fraud and identity theft and to improve the accuracy of screening and vetting processes. The policy update reverses temporary flexibilities introduced during the COVID-19 period. Those measures allowed the reuse of photographs for up to 10 years, even when a person's appearance had changed. USCIS said these flexibilities were kept in place longer than needed and weakened its ability to properly verify and identify applicants. According to USCIS, strong screening and vetting are essential to maintaining the integrity of the U.S. immigration system. The agency said the new photo rules align with the Department of Homeland Security's broader push to modernize immigration processes and close gaps in identity verification. The update also states that some immigration forms will require a new photograph regardless of when the applicant's last photo was taken. These include Form I-90 for replacing a permanent resident card, Form I-485 for adjusting status to permanent residence, Form N-400 for naturalization, and Form N-600 for a certificate of citizenship. USCIS said the policy guidance is effective from the date of publication and applies to all relevant applications filed from that point onward. Trump's $100,000 H-1B visa fee draws legal challenge from U.S. states. California and 19 other U.S. states filed a lawsuit on Friday seeking to block President Donald Trump's $100,000 fee on new H-1B visas for highly skilled foreign workers. The lawsuit in federal court in Boston is at least a third to challenge the fee announced by Trump in September, which dramatically raises the cost of obtaining H-1B visas. Currently, employers typically pay between $2,000 and $5,000 in fees. California Attorney General Rob Bonner's office said in a release that Trump lacks the power to impose the fee, opens new tab, and that it violates federal law, which allows immigration authorities to collect only fees necessary to cover the cost of administering visa programs. The H-1B program allows U.S. employers to hire foreign workers in specialty fields. The tech industry, with many companies headquartered in California, is particularly reliant on workers who receive the visas. Bonta, a Democrat, said the $100,000 fee would create unnecessary financial burdens for providers of vital services such as education and healthcare, exacerbating labor shortages and threatening to cut services. The states joining California in the lawsuit include New York, Massachusetts, Illinois, New Jersey, and Washington. The White House, in response to other lawsuits, has said the new fee opens new tab as a lawful exercise of Trump's powers and will discourage employers from abusing the H-1B program. Critics of H-1B visas and other work visas say they're often used to replace American workers with foreign employees who will work for less. But business groups and major companies have maintained that workers on H-1B visas are a critical means to address a shortage of qualified American workers. The U.S. Chamber of Commerce, the country's largest business lobby, and a coalition of unions, employers, and religious groups have filed separate lawsuits challenging the fee. A judge in Washington, D.C., is set to hold a hearing in the Chamber's lawsuit next week. Trump's order bars new H-1B recipients from entering the United States unless the employer sponsoring their visa has made the $100,000 payment. The administration has said the order does not apply to existing H-1B holders or those who applied before September 21st. Trump in the order invoked his power under federal immigration law to restrict the entry of certain foreign nationals that would be detrimental to U.S. interests. Bonda's office said on Friday the $100,000 fee far exceeds the cost of processing H-1B petitions, rendering it unlawful. It added the U.S. Constitution bars Trump from unilaterally imposing fees to generate revenue for the United States, a job that is reserved for Congress. DHS announces a termination of temporary protected status for Ethiopia. Today, Secretary of Homeland Security Kristi Noem announced her decision to terminate the temporary protected status designation of Ethiopia. Temporary protected status designations are time-limited and were never meant to be a ticket to permanent residency, said a USCIS spokesperson. Conditions in Ethiopia no longer pose a serious threat to the personal safety of returning Ethiopian nationals. Since the situation no longer meets the statutory requirements for a TPS designation, Secretary Noem is terminating this designation to restore integrity in our immigration system. Ethiopian nationals with no other lawful basis for remaining in the United States have 60 days to voluntarily depart the United States. We encourage aliens leaving the United States to use the U.S. Customs and Border Protection CBP Home mobile app to report their departure from the United States. This is a safe, secure way to self-deport that includes a complimentary plane ticket, a $1,000 exit bonus, and potential future opportunities for legal immigration. After February 13, 2026, the Department of Homeland Security may arrest and deport any Ethiopian national without status after their TPS has been terminated. If an alien forces DHS to arrest and remove them, they may never be allowed to return to the United States. Trial begins for Wisconsin judge accused of helping immigrant evade federal authorities. Milwaukee County Circuit Judge Hannah Dugan is charged with obstruction and concealment and faces up to 6 years in prison if convicted on both counts. A prosecutor told jurors Monday that a Wisconsin judge said she would take the heat for directing an immigrant to dash through a private courtroom door while federal agents were trying to arrest him. Opening remarks by Assistant U.S. Attorney Keith Alexander kicked off an extraordinary trial for a public official. Milwaukee County Circuit Judge Hannah Dugan is charged with obstruction and concealment for her actions this spring during President Donald Trump's immigration crackdown. The trial in federal court in Milwaukee will center on what happened when Eduardo Flores Ruiz, 31, reported to the county courthouse in April for a hearing on a state crime. Authorities say Dugan let him out through a back door that led to a public corridor after she told immigration agents to speak with the chief judge about trying to arrest people at the courthouse. They did not expect a judge, sworn to uphold the law, would divide their arrest team and impede their efforts to do their jobs, Alexander told the jury. He said Dugan informed her court reporter that she would take the heat for helping Flores Ruiz. The government's case is expected to run through at least Thursday, with roughly 24 witnesses lined up to testify. Dugan faces up to 6 years in prison if convicted on both counts. During his opening remarks, defense attorney Stephen Biskupik said the judge had no intention of obstructing agents. He said Dugan was following policy when she directed federal agents to Chief Judge Carl Ashley's office. Biskupik said other agents still in the courthouse hallway decided not to arrest Flores Ruiz when he emerged through the door and instead followed him outside the building. Now, after the fact, everyone wants to blame Judge Dugan, Biskupik said. Flores Ruiz was arrested after a foot chase. The U.S. Department of Homeland Security announced in November that he had been deported after he pleaded no contest in the local battery case and was sentenced to time served. Ahead of the trial, U.S. District Judge Lynn Adelman declined to dismiss the charges, saying there was no firmly established immunity for Dugan. Democrats say Trump is looking to make an example of Dugan to blunt judicial opposition to immigration arrests. Dugan told police she and her family found threatening flyers at their homes this spring. The administration has branded her an activist judge. Republican U.S. Representative Tom Tiffany, a fierce Trump loyalist running for Wisconsin governor next year, urged authorities to lock her up in a recent social media post. That is all for today. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. Till then, take care